All right, the defendant would please rise with counsel. State of Ohio versus Carl Wayne Wimpey Jr. Verdict for count 1. We, the jury, in the above entitled action, for verdict, find and say that we find the defendant Carl Wimpey Jr. not guilty of count 1, murder, in violation of 2903.02b and revised code 2929.02. Appears to be signed by all 12 jurors. Count 2. We, the jury, in the above entitled action, for verdict, find and say that we find the defendant. I'm going to go with the verdict form for lesser included first. I apologize. Let me start over. We, the jury, in the above entitled action, for verdict, find and say that we find the defendant, Carl Wayne Wimpey Jr., not guilty of the lesser included offense voluntary manslaughter, 2903.03a and 2929.14a1, appears to be signed by all 12 jurors. We, the jury, in above entitled action, for verdict, find and say that we find the defendant, Carl Wayne Wimpey Jr., guilty of the count of felonious assault, 2903.11a1 and d, appears to be signed by all 12 jurors. Counsel, approach, please. So you can be seated if you'd like. You can move this a little bit easier. Do you have any request upon the jury?
No.
No, Judge.
Okay.
They signed it.
All right, thank you. The jury verdict will be received, and the court will excuse the jurors to the jury room. I'll be with you in just a few moments to answer any questions you have afterwards. Thank you.
All rise for the jury.
Counsel, we have the verdicts. The next will be to schedule a sentencing date. Are there any requests?
Your Honor, I don't know as to the date, Your Honor.
The date, and normally the court would do a pre-sentence investigation report. I would imagine that both parties would prefer that that is conducted. That gives the background of the defendant to the court prior to sentencing.
That is correct, Your Honor. I just need at least a couple of weeks, Your Honor, so I can get all caught up with everything at the office. As to that, Your Honor, and Your Honor, we're also asking that the defendant be allowed to be released to go back to his children and do the pre-sentence investigation and come back for sentence.
Well, he currently has a bond where he is on electronic monitoring with a cash bond posted, correct?
That is correct, Your
All
Honor.
right, so that, is there any objection to that bond remaining in effect, Mr. Spryzak?
No.
All right, the bond remain in place. We'll set the sentencing date. Mr. Kerner, since you're present, can you approach? I have to ask you a quick question on the other days. I think the other one for Thursday or late morning, simply because of the he's October 25. He's not going to be able to be ready for next Thursday.
Okay.
This is I'm looking at maybe Thursday the 8th. In November.
In the afternoon?
Yeah, well, I'll do afternoon or morning, whichever one's better for you. I prefer like late morning.
That's fine.
That work?
Yeah, that's no problem. As long as you're not doing it on the docket. That's all that my concern is.
Yeah, I think that's why we're doing it later on.
Yeah, like at 11 o'clock or something? Yeah, that's fine.
Okay. All right. Mr. Ayad, I'm looking at Thursday, November 8th at 11 a.m.
That should work. That should work, Your Honor.
All right, thank you. We'll set sentencing for Thursday, November 8th at 11 a.m. Bond is ordered to continue. Court is in recess.
Thank you.